going to try to attempt to throw out some common sense today on this video that isn't based in the traditional scholarly interpretations of the Constitution, but rather is based in the text of the Constitution, which James Madison said the only valid meaning of the Constitution is the original public meaning, or in other words, what the public would have understood when they sat down reading it, what the words meant, etc. Nothing about the intentions. He didn't want his notes from the Constitutional Convention to be used. Jefferson said the same sort of thing, and he was probably even a better example of it because he didn't participate in the Constitutional Convention. He had a very cautious nature, perhaps, versus Hamilton had a little bit more of an aggressive nature. And so sometimes I think that Jefferson, even though mostly I prefer his way of looking at the Constitution, I think even sometimes he was overly cautious. The Louisiana Purchase was constitutional, for example. We can have that conversation another time. I've done videos on it, but let's talk about a straightforward concept. John Taylor, Brigham Young, people like that said that when the Constitution was getting made, these are prophets of the Church of Jesus Christ of Latter-day Saints, that when the Constitution was getting made, the founders probably didn't know that what they were writing down was what God wanted them to write down, but nevertheless, that's what was happening, right? So, in other words, God said He established the Constitution. It's a divinely inspired Constitution. If you're President Oaks, or it's our divine Constitution. If you're President Benson, J. Reuben Clark said it's basically might as well be part of the Doctrine and Covenants, etc., etc. We've got enough of this kind of idea. Frederick Douglass, to kind of dig into this a little bit more, somebody who's not a leader of the Church of Jesus Christ of Latter-day Saints, said after examining the Constitution that you could abolish slavery and not have to change a single word in the Constitution, that it was a glorious liberty document, because there is no explicit endorsement of slavery actually in the Constitution if you look at it. And yes, servitude being owed is a concept that we still have to this day. Read the 13th Amendment, you guys. It's not like we actually did away with it. So anyone who points to clauses in Article 4, what have you, regarding servitude being owed and things like that, and says that's an endorsement of slavery. No, it's an endorsement of, read the Book of Mormon. I mean, like, when different soldiers from invaders would be captured, they would then be forced into servitude. This is like literally one of the oldest forms of punishment out there in history. So anyhow, moving on, the Constitution itself declares itself to be the supreme law of the land. They might not have intended for it to be interpreted the way I'm about to interpret it, but it's besides the point. I don't care what their intent is. In contract writing, you either write it down right, or you're stuck with what you wrote down, okay? The original public meaning, and then everybody else is allowed to hold you to it. And if you realize, oops, there's something I missed, that went wrong, there's an amendment process. Fix it right, don't fix it wrong, okay? But anyhow, it declares that the Constitution, the laws, and the treaties are the supreme law of the land. So therefore, the final law, when all other laws are put to the test, or even John Marshall, when he says in, what's the case, Marbury versus Madison, he says, when two laws are before you regarding a case, it's the judge's job, first off, to determine, to ascertain through the pure way our structure is set up, which of those two laws overrides the other one if they're seemingly in conflict, okay? So again, the real thing is, and then he basically said the Constitution is the supreme law over the Judiciary Act that they had back in, 1789, I want to say, right? So anyhow, even John Marshall himself looked at the Constitution as a law. Now, I know there's a quote out there from Joseph Smith, and where he says the Constitution is not a law, but is the power to make laws. Yet at the same time, Joseph Smith said that any officer of government who takes an oath to support the Constitution but then does not defend the rights vouched, safe, or guaranteed in the Constitution deserves to potentially be subject to the death penalty, something like that. In other words, it is clear to us, to we the people, that the text says this is guaranteed, that's guaranteed, that's guaranteed. And that's all we know is what the text says. We should be allowed to expect that. And the officers of government, where it's guaranteed, it's not optional for them to do something about it. Even if there's no further legislation prescribing thresholds of violation and thresholds then of sentences, etc., passed through the Article 1, Section 7, Clause 2 process, it doesn't matter. You still have the option of doing what's called a case in equity. And no, I'm not a legal expert but a case in equity basically means where there is no pre-written down law. Correct me again in the comments if any of you can give me further insight on this. I will keep researching the term, but I've been developing my understanding of it over the past couple of years or so. A case in equity basically means there's no written down law. It's just right is right, wrong is wrong. Somebody did something that's wrong, and so you have standing, you're bringing a suit. That's all there is to it. So now let's talk about who was authorized to simply do something to execute the laws of the land in the Constitution. Well, first off, the state officers are obligated to it. So Article 6, Clause 2 and 3 basically obligate specifically the state officers to defend the Constitution first. Clause 3 really obligates all officers. Okay. Article 1, Section 8, Clause 15 is the power to call forth the militia on the legislative branch's part to execute the laws of the land. So that's actually, if you think about it, that's an executive power to a certain degree granted to the legislative branch, right? Article, according to a plain reading, and again, Madison said that's the only valid meaning. Jefferson especially said that multiple times. They also said if the laws became so numerous that it was impossible for a smart, average, intelligent citizen to understand it, that the Constitution would be worthless. You guys know, by the way, typically, I've looked up the statistics from different periods, typically about 50% of the people participating in running our government at the legislative level, etc., are lawyers. The rest of them aren't. These are just smart people. So I'm talking about like the legislature, right? Where you would think, oh, they have to be lawyers in order to be able to legislate. No. So this is supposed to be understandable. It is not supposed to be so out of control that we can't understand it for ourselves. So now, coming back to it, Article 2, Section 3 has the take care clause. It's already covered Article 1, Section 8, Clause 15. Power to call forth the militia, which then that's basically the legislative branch having the militia execute the laws. The Article 2, Section 3, the President's take care clause, that's not a power, that's an obligation to me. Obligations are more powerful than powers, and I know the Supreme Court acts like they don't know what the heck to do with those. I keep saying you got to stop looking at it as though it's nothing but prohibitions and powers granted, right? There are promises guaranteed, and where a promise is guaranteed, even the Supreme Court now, Article 3, Section 2, Clause 1, the judicial power of the United States shall extend to all cases arising, all cases in law and equity arising under this Constitution, the laws and the treaties, etc. Something to that effect, basically. Cases in law, cases in equity. Laws do not, you don't have to go through the Article 1, Section 7, Clause 2 process for a case to be able to be brought, for charges to be able to be brought, to be able to decide some kind of resolution. And in that moment, then this is where President Oaks talks about, then that's the Supreme Court then saying, okay, what can we do about this? Or the judicial branch saying, what can we do about this? Since there are no pre-written laws, but clearly a constitutional promise has been violated. And they should still be able to prescribe remedies. That's the way I understand it. Again, correct me if I'm wrong. But now getting to the promises, the Constitution has promises in multiple spots, if you ask me. Preamble is pretty much when it says insure or anything like that. And some people say, no, the preamble is not binding. Once again, I make contracts with my business. I provide an opening statement. This is what my business is. This is the services we provide, right? If somebody wanted to sue me for showing up to their house, following all the rest of the clauses within the contract, but then when I get to their house, instead of providing the service that I say I'm supposed to provide, I start working on their countertops for them, or I start, doing this or that, they would absolutely be entitled to sue me. Yes, the preamble matters. The opening statements matter. That's all there is to it. but the majority of the promises guaranteed you're going to find in the Bill of Rights and in Article 4 of the Constitution. And so let's look at a very relevant one that's in the news right now, if you ask me. And a lot of people are going to say, no, Jason, that's Article 1, Section 4, or no, that's Article 2, Section 1, where it talks about the times, manners, and places of elections regarding the selecting the electors, right, for the president, etc. Article 4, Section 4 says the United States shall guarantee to every state in the Union a Republican form of government. Again, me paraphrasing. A Republican form of government, it is impossible for it to be a Republican form of government without the people's consent being given to it. Okay? And it is impossible for it to be the people's consent if it's a forced consent. In other words, if it's a manipulated consent, you can say, oh yeah, we counted the ballots. Yes, but how many of those ballots that had votes you didn't want did you throw away and replace with ballots that had votes you did want? Or whatever. Any way that you force the consent to be what you want the consent to be, it's not consent, right? And so it's impossible for it to be a Republican form of government. So the United States doesn't suggest that it might help out in trying to encourage a Republican form of government in the states. It says it shall guarantee to every state a Republican form of government. So if you have election integrity issues, then whose prerogative is it to deal with that? Well, you might say Congress, Article 1, Section 4. No, Article 2, Section 1, right? Where the privileges or times, manners, and places, right? No, that's true, yes. Which then it does fall under a case arising under the Constitution. That's all there is to it, right? But what about the Take Care Clause? Again, got to remember, the Constitution itself declares itself a law. John Marshall used that exact same rationale. He said two laws are in conflict, right? The Judicial Act of 1789 versus the Constitution itself. He would describe those as literally two laws in conflict, right? The president has the Take Care Clause. He shall take care that the laws are faithfully executed. And now what's the enforcement mechanism that the president's been granted? As best as I can tell, it's the Army, the Navy, and the militia when called into actual service. Okay, so anything else constitutionally doesn't exist, but departments can be created. It does acknowledge that in Article 2, Section 2, and that the president can appoint leaders over it. But in the end, who has the take care responsibility? Whose shoulders does it fall on no matter what? The president's. So, first off, obviously if the president is saying, hey, you states got to get your elections together, there is something wrong, this is embarrassing, that's the least he can do, you guys. All right? This whole reaction from ABC, I'm sorry, dudes. But I think he's even got more authority, because he shall take care of the laws of the land be faithfully executed. Okay? That means he's got standing for one of those cases in equity. That means he can sue the state of California, and if the Supreme Court doesn't honor it, you know what? They're out of control. They need to pay attention. They need to stop paying attention to their own previous decisions, their own precedent, and start paying attention to the actual text, the original public meaning, what we the people, after studying the entire Constitution, would conclude. You know, they might say, Barry v. Baltimore. Well, the Fifth Amendment was originally intended to be included in part of Article 1, Section 9, which really meant it was only supposed to be a prohibition on the United States Congress. I don't care. That's not the way it turned out. So the way the public would understand it, the reason the case was brought by one of the best attorneys that we had in the United States at the time is because the way the plain text of the Fifth Amendment read, it was a blanket prohibition on all levels of government. So it was, Joseph Smith would say, if you don't stand up for defending that, if you've taken an oath of office to the Constitution, we should be considering the death penalty for you, basically, right? Just say it. That's how serious he thought it was. That the people, when they are promised, when they can read the Constitution for themselves and see, it promises me this, but the government's doing that to me. It's not we the people that are wrong. It's the government that's wrong. This is the plain stance of Joseph Smith. I want to go ahead and emphasize something more real quick here too. I do believe I've been emphasizing this a lot lately. The First Amendment to the Constitution enshrines the right to imitate basically what the Continental Congress to assemble and peaceably petition for redress of grievances. That's what's actually constitutionally protected. Rioting in the streets, etc., is not constitutionally protected. I got some Jeep in a hurry here on these country roads wanting to pass me. Have at it. Enjoy driving 70 miles an hour in a 50. But anyhow, oh, what was I going to say? Still the same. Shays Rebellion. It was farmers arising against, these investment class, these elites that were being supported by the government, and it was a specific type of target. The Tea Party, Boston Tea Party, same thing, a specific type of target, fits in the same category. January 6th, oh man, how dare you bring that one up. Again, the specific type of target. Congress, get your act together. Look into the integrity of these votes that are being presented to you. Look into the integrity of these electors, right? Was it as effective of a means as a Continental Congress? No. And there's a reason why our founders, if you ask me, did not enshrine into the Bill of Rights the power or the right to repeat the same thing as the Tea Party and things like that. But they did enshrine into it. So more effective would have been peaceably assemble and petition for President Trump to be looking into the corruptness of the way all these plea bargains were handed to all the people accused and wanting to overturn them. Yes, that's absolutely his prerogative. As a matter of fact, there's a guarantee really of a Republican form of government in the United States. And so I would say he would be abdicating his duty if he didn't look into that. And Joe Biden definitely abdicated his duty. Left and right, non-stop, all day long. But he wasn't competent. Even Barack Obama, I think. I wasn't paying attention as much back then, but I think Barack Obama, all those other guys were actually a lot better at, not abdicating as much. I think when you look at, I'm going to give one more comparison, the George Floyd riots, constantly the target was just randomness. That's the most terrible thing that we've ever had happen in America. And when you look at also, the most terrible thing was the Civil War. That was out of control. That was not part of the President Lincoln's Take Care Clause. There was no text he could point to in the Constitution. He had to come up with explanations. He had to start looking at the Articles of Confederation, which the Articles of Confederation were null and void. Same thing with Jackson. There was no text in the Constitution he could actually point to. He had to twist the meaning of Article 6, Clause 2, and basically turn it into the Declaratory Acts or the Coercive Acts or something like that of Great Britain, for all intents and purposes. Where Van Buren failed to defend the Mormons, Article 4, Section 2, Clause 1, Fifth Amendment, all sorts of stuff, they should have been able to expect protection, right, from him, because he had an obligation, with or without additional legislation, with or without application from the legislatures or the governors. And so I'm coming back to what Frederick Douglass said, examining the Constitution, just the pure words of it. Do away with slavery. You don't have to change a single word of the Constitution. The words of it are already perfect. Brigham Young said, whether or not they knew it, they were writing what God wanted them to write. Even down to the Fifth Amendment that Madison wanted to include it in Article 1, Section 9. They said, nope, it's a standalone amendment. It's more powerful that way. And to me, 13th, 14th, and 15th Amendment all come after a lot of these sayings. I think those are where the real disaster begins, honestly. The way they were passed wasn't through the people's consent, right? Unless I'm going to give you your one explanation for why the Civil War might be constitutional. You ready for it? If you believe that conquering an adjacent territory, like was attempted in the War of 1812, is legitimately constitutional, right? for the sake of common defense because you feel like you're threatened by this adjacent superpower, right? Then what you have to acknowledge is the South successfully seceded. They were no longer part of the Union, right? And you just didn't like it. You decided you wanted to go conquer them, go take it back. Nah, you're stuck with being part of us, so we're going to steal you back, right? That's the only legitimate explanation you're ever going to come up with that validates whether or not it's constitutional. I've thought about this long and hard. It's as constitutional as the War of 1812 in that regards then. And it's questionable. Is that common defense, conquering adjacent territories? Yeah, it can be though, right? So that's the best I've got for you justifying that. Again though, election integrity. It cannot be a Republican form of government if there is no election integrity, because that's not the actual will of the people. And yes, the take care clause and the fact that the Constitution itself calls itself a law, which Supreme Court justices have agreed with that term, right? Then it's a law that falls under the president's take care clause. What else can it be? According to the plain text of the Constitution, nothing else makes sense. So thanks for listening, guys. See you.